Okay, so it's for University of South Florida constitutional law class. I've totally never done any of this ever before, but here it goes. Gideon versus Wainright. Gideon versus Wainright occurred in June 1961, in which case a Clarence Earl Gideon had previously been arrested for allegedly stealing from a pool hall. A few beers, some liquor, and a pocket-sized amount of change later, Gideon had been arrested for theft. Being a local drifter, if you will, with a not-so-good and accompanying criminal record, in conjunction with the accusations at hand, Gideon found himself in jail literally overnight and with no money, or family, or even a friend to help make bail, much less hire an attorney. Gideon, upon being heard by the Florida court in which his case had been appointed in Bay County, Florida, had requested that the court, in conjunction with the Sixth Amendment, appoint him counsel, being it was that he couldn't afford an attorney and that none had been provided for him. The court denied Mr. Gideon's claim. This was due to the idea, at least in Florida, prevalent at the time, that only capital cases required such an appointment according to Florida law. Counsel was only provided in capital cases, and as such, Clarence Earl Gideon was, as one would later suspect, found guilty and sentenced to 5 years in prison for the accused crimes. Gideon v. Wainright is significant to America in that it represented the world and said that in the American judicial system, the right to be represented when accused of a crime and when you can't afford to pay for a lawyer was innate. Prior to the court ruling, however, the standard and accepted legal precedent at the time was seated largely on precedent of which originated with and was formulated by that of Betts v. Brady, a 1942 case in which the Supreme Court stated that the 14th Amendment of the United States Constitution does not embody an inexorable command that any indigent defendant in state court is entitled to a court-appointed, state-compensated counsel. Rather, the opportunity to obtain counsel is more to the point of what is required and meant by that of the 6th and 14th Amendments. As for Mr. Gideon, post-trial in Florida and from his prison cell, he claimed that the conviction was unconstitutional. In a letter to the Supreme Court of the United States, Clarence Gideon from his prison cell in Florida wrote and asked of the court to command, based off federal and constitutional law, that the Supreme Court hear his case and thus dictate, as he states, or so request, that the Supreme Court of the state of Florida vacate the sentences on the grounds that I, Clarence Earl Gideon, was made to stand trial without the aid of counsel. The said court refused to appoint counsel and therefore deprived me of due process of law and violated my rights in the Bill of Rights and the Constitution of this United States. Clarence Gideon in a letter from prison. Upon hearing Mr. Gideon's request, via the informa papicus files of the court and the United States Supreme Court, the court appointed a Mr. Abe Fortes of Washington, D.C. to counsel for Mr. Gideon. Mr. Fortes would later become a Supreme Court Justice himself. In a statement made to CBS Reports in 1964, Mr. Fortes stated that the time had arrived when the court, with a proper case before it, would lay down the federal rule that every man, the poor as well as the rich, was entitled to the benefit of counsel. The representation of Mr. Gideon by Mr. Fortes would prove more than essential. On March 18, 1963, the United States Supreme Court unanimously ruled that the Constitution requires states to provide attorneys to defendants who can't afford them, based on the language used in both the 6th and 14th Amendments, as reported by CBS this morning, Saturday, March 16, 2013. Following the decision, Gideon was given a new trial with an attorney and was acquitted of the charges. Bruce Jacob, former Assistant Attorney General for the state of Florida during the early 1960s and prosecuting attorney in the Gideon case, argued against Gideon in the Supreme Court. Jacobs on CBS this morning, again March 16, 2013, would later be recorded as saying, "The courts have not gone as far as they should in implementing the Gideon ruling." And as such, and in nearly the same breath, Mr. Jacob also stated that our system hasn't performed as well as it should in regards to providing proper defense for those accused of a crime, and in whom were also declared indigent. Bruce Jacobs, CBS, March 16, 2013. And Mr. Norman Dorson, who wrote the brief for Gideon v. Wainright, also stated in the same showing that the promise of Gideon has not been fulfilled, and that not nearly enough money nor lawyers have been dedicated to fulfilling the promise of Gideon post this landmark Supreme Court case, despite his earlier thoughts on the case. Norman Dorson, being the former president of the ACLU and author of the Gideon v. Wainright brief, in point of fact, it is estimated that nearly 80 to 90% of all persons charged with criminal offenses qualify for indigent defense. Gideon v. Wainright set the stage for a great turning point in American jurisprudence in that it finally allowed and defined for American citizens everywhere what the standards were as they pertain to a fair trial in terms of American judicial standards. Though currently not even remotely enough, the Gideon case made it possible for more funding to be allocated and more attorneys hired and more time being spent on that of protecting the rights of everyday and ordinary citizens in regards to false accusations, wrongful convictions, and the wrongfully accused. Gideon also helped to significantly increase the amount of defendants that post-Gideon v. Wainright would be or could rather be heard by and spoken for via that of an attorney as opposed to themselves, and thus finally granted the due process and equal protections deserved as a citizen of the United States in such a proceeding. And so is the story of how one man, a poor prisoner, took his case to the Supreme Court and changed the law of the United States forever. Also worthy of note, and as quoted just prior, is the book by Mr. Anthony Lewis, written in detail and later used to inspire and direct the alike title, Gideon's Trumpet, of which Henry Fonda starred as Mr. Gideon. Books and movies aside, though, Gideon set a certain legal precedent within the context of American jurisprudence, one that I believe has been essential to not only that, but has seemingly brought us miles from that of Betts v. Brady, one that somehow and similarly brought us yet even closer to home, home being that of a free society in which the wrongful incarceration of an innocent person or persons is more taboo than the unassured release of one in whom may, despite being suspected of guilt, if but only because of reasonable doubt, is somehow released, if but only because the wrongful conviction of the innocent leaves us no more guilty and so stained as the guilty. As a free society, we embrace and even celebrate this innocence by protecting that of the free and the accused, and ensuring guilt be proved beyond that of a reasonable doubt, as to harbor and refrain ourselves from such wrongfulness as to, per se, murder an innocent man, or imprison said suspect for a crime of which they did not commit, etc., as Gideon was so wrongfully accused, and then thus convicted. For more resources and better summary of the facts, please visit the Supreme Court website, of which you can listen to a podcast of the Supreme Court proceedings in Gideon v. Wainright, which will be followed at www.uscourts.gov/multimedia/podcast/landmark/Gideon v. Wainright.aspx. The Gideon proceedings is that of which has allowed many of I gotta stop. Can't do it.